it was like 2 or 2:30 in the morning, and she's screaming in the common stairway to wake up Miss Smith and have Miss Smith come out and confront her. So that's what for Miss Burns had testified to at the examination. So just to give the court an understanding of the situation, the body cam footage shows Miss Smith, her shirt completely ripped off when the police come to her. She's covered in blood. The other parties, Miss Burns isn't covered in blood. She's in her apartment. She's acting hysterical because that's the way Miss Burns is, but she is not showing the same injuries that Miss Smith was showing. Now they did, I apologize again, I don't remember his name, but the other party involved in the fight. And Miss Smith contends that she was assaulted. She pled disorderly, obviously, because it was loud and it just did disturb the public peace, and she admitted that. But going on to the resisting and opposing officer, Miss Smith that day she was undergoing treatment, chemo treatment. Again, the incident, taking what Miss Burns had said, she's awoken at 2:30 in the morning, and then this incident occurs and the police come. Miss Smith did have a warrant out for her, which is ultimately why she was arrested, but realized that she was just involved in a pretty savage physical incident, however you want to categorize it. Again, Miss Smith insists, and I believe that she was assaulted, but again, that's not, they were in charge. I don't know what was going on with them. Miss Burns, I think, Miss Smith had indicated she did have prior, I don't know if it's still active, a PPO against Miss Burns. There's a no contact request moving forward. Miss Smith has no issue with refraining from any contact with Miss Burns, because Miss Burns seems to have issues with this other than with Miss Smith as well. But again, in regards to the officer, Miss Smith does apologize for that. If you watch the body cam, you can see the officer thinks that she's intentionally spitting on him. That's just because of her medical issues. She was, again, hysterical, trying to get things taken care of. So again, she does apologize for that, Your Honor. I ask to take that into consideration when passing a sentence here. We believe a period of probation will be appropriate. We understand Ms. Smith's past history. There is concern about that, as Mr. McCarron had expressed. But again, Mr. McCarron, he did express he wants to give Ms. Smith a chance on probation because of this. Again, jail time, incarceration time probably isn't very fruitful for Ms. Smith, also because of her medical injuries or medical issues. What care they provide at the jail is an issue as well. So I'd ask the court to consider a period of probation. I'd ask the court to consider maybe less than 12 months. But again, just a period of probation, I believe, is appropriate, no incarceration. Or if the court, again, even though Mr.
I'm just going to do fines and costs, Mr. Murphy.
Well, thank you, Your Honor. I will shut up now.
Okay, thank you. Anything you want to say on your own behalf?
Yes, Your Honor. I mean, I take full accountability for, I guess, acting the way I did that night. I don't usually act like that towards officers or anyone in general. And I'm taking better steps to better my life for me and my daughter. And it's been a long journey for me, but I'm here, and I'm just gonna keep doing what I'm doing. I go to the Y and stuff, so therefore it helps. I just wanted to let you know that I'm sorry.
Okay. So, in determining the appropriate sentence in this case, the court has considered the seriousness of the offense, your history, the principal proportionality, the statutory penalty, the cost of confinement, sentencing guidelines, the report and recommendation of the probation department, as well as what has been said upon the record in this hearing. The criteria and reasons for the sentence are the nature and gravity of the offense, the discipline appropriate to its commission, deterrence against repetition by you and by others, potential for reformation, vindication for law, and protection of society. Ms. Smith, stay away from her. She knocks on the door, she yells from the floor downstairs.
Anywhere near there, you know.
All right, I don't want you to have any involvement with her at all. If you see her, go the other way.
Understood.
Okay, and I think you'll do that in light of the fact that you receive SSI and you have a lot of medical out-of-pocket costs, and you're receiving Medicaid and food assistance. I don't see the purpose of placing her on probation or assessing any court costs or anything. She doesn't have the ability to pay, so I'm not going to do that. I have to assess a $75 crime victim rights fee and $50 in state costs. So that comes to $125. I would just really appreciate it if you paid it the next 6 months. All right.
I understand.
And I don't care if you paid $20 a month, so it gets paid off. My bailiff's going to hand down to you your notice of right to appellate review. I'm going to have you initial and date the top copy. The other copies are for you. If you wish to appeal the sentence, you would fill out the information on the form and mail it to the address listed on the form within 42 days. I just don't see that she financially could afford probation.
Yes, Your Honor, thank you. I was gonna ask for.
Doing well.
Ms. Courtney Smith, as I said, this was reduced to an attempted R&O and a disorderly. I don't want to, no more. Don't engage in this behavior again, all right? All right, thank you, Ms. Smith.
Thank you, Your Honor.
Happy holidays.
Happy holidays. The record should reflect I received back a signed copy of the notice of right to appellate review. All right, so Ms. Hannawalt, thank you so much for your patience this morning. Mr. Glazier is, yep, let me double check. Yep, Mr. Glazier's your attorney. So why don't you come on up to this podium? Mr. Glazier, this is in the matter of the people of the state of Michigan versus Lisa Marie Hannawalt. We have two files, 23-21232 FH and 24-21857 FH. I have John Glazier appearing on behalf of Ms. Hannawalt. Mr. Glazier, for some reason, I don't know why, we didn't have prints on file number 23-21232 FH. And Ms. Hannawalt was kind enough this morning to go over to the sheriff's department to get those fingerprints, and they worked with you and did that?
Yes, ma'am.
Excellent. All right, so Mr. Glazier, you received a copy of the pre-sentence report?
Yes, I did, Your Honor.
All right, so Ms. Hannawalt, have you had an opportunity to read and review the pre-sentence report?
I went over it a little bit with Mr. Glazier.
Okay, so you say you went over it a little bit.
Well, I did read through it, yes.
See, that might kind of twist it towards you. There you go. All right, so you did get to read through
Yes,
it?
ma'am.
All right, and did you get to ask any questions you might have to Mr. Glazier? Or do you need
Yes.
more time?
I did ask him.
You did? All right, and do you, are you satisfied with Mr. Glazier as your attorney and the advice that he's given you?
Yes, ma'am.
All right, Mr. Glazier, do you wish to explain or challenge the accuracy or relevancy of any questions or any information in the pre-sentence report?
No, Your Honor.
Does the pre-sentence report disclose any prior convictions in which there exists any known constitutional defect?
No, Your Honor.
The probation department has computed the minimum sentencing guidelines to be 0 to 6 months. Do you agree with that computation of guidelines, Mr. Glazier?
Yes, I do, Your Honor.
All right, I do show she has one prior misdemeanor. All right, so Mr. Glazier, before the court passes sentence, let me ask, Mr. Coast, what case were you popping in on? Mr. Coast, are you in your office? He's not. Okay, so before the court passes sentence, Mr. Glazier, anything you want to say on behalf of Ms. Hannawalt?
Your Honor, just this situation where my client has some mental health issues. She is in counseling right now and she is taking her medications. I know the if I read it right, what the pre-sentence on the UDAA was for probation, enter and complete, stay on her meds and things. The assault and battery recommended 30 days with credit for time served. We'd ask the court to suspend that. Perhaps my client's doing a lot better than when I saw her last time. She's evidently taking care of her mental health issues.
Okay. Anything you want to say on your own behalf, Ms. Hannawalt?
Yes, ma'am. I was going through a horrible divorce time.
I speak up a little bit for me. I'm sorry. I know it's hard.
I was going through a divorce at the time and I made a few bad choices. I was married for 22 years and it was rough, but I take responsibility for my actions, and I'm a grandmother and I'm happy to be with my family, and I would appreciate the court if they would see that I am doing a lot better and working with what I have with. Thank you.
Okay.
There was one other thing I was going to indicate. She ended up doing 45 days in jail on a contempt of court on that assault and battery. And so she's already spent, some time on that. And we'd ask the court if it consider suspending any other, or not giving her jail time on the A and B.
Okay, thank you. All right, in determining the appropriate sentence in this case, the court has considered the seriousness of the offense, your history, the principle of proportionality, the statutory penalty, the cost of confinement, the sentencing guidelines, the report and recommendation of the probation department, as well as what has been said upon the record at this hearing. The criteria and reasons for the sentence are the nature and gravity of the offense, the discipline appropriate to its commission, deterrence against repetition by you and by others, potential for reformation, vindication for the law, and protection of society. And, okay. Mr. Coast, are you there? No. All right. So, Ms. Hannawalt, on file number 23-21232FH, I'm going to place you on probation for a period of 18 months. During that term of probation, you're not to violate any laws or get in trouble. You can't leave the state of Michigan without consent of Ms. Walsh. Do you travel to Ohio?
I do, my daughter.
Okay.
One of my children live in Ohio.
In Lucas
Well, actually,
County?
both of my children live, my one daughter lives in Lucas and one lives in Fulton.
One lives in
One
one.
lives in Lucas County and one lives in Fulton County. My oldest daughter Amanda lives in Swanton, Ohio. It's Lucas County.
All right, so Ms. Walsh, I will allow her to travel to Lucas and Fulton County for visiting family. It's Toledo, I don't know. So I will allow that. During your term of probation, not to use any alcoholic beverages. I understand like the medication you're on would interact with anyway, so you shouldn't be doing that. You must comply with all alcohol and drug testing. Use prescription drug medication only as prescribed. Complete any outpatient or residential substance abuse treatment if referred to by the agent. Complete an assessment if they need you to. You're going to have to report in person or in writing, whatever Ms. Walsh requires, and we'll talk to her about that in just a minute. If they order a psychological evaluation, you have to comply with that. If you change address or employment status, you're going to need to make sure you notify her right away. No contact with Gabrielle Villanueva, either directly or through another person. Can't be near their residence, school, place of employment. You must obey all court orders. Can't engage in any assaultive, abusive, threatening, or intimidating behavior. You don't visit anybody in prison, do you?
No.
Okay, we can't do that. Can't have in your home any weapons, okay, and not use any item as a weapon. Comply, and you must obey and comply with all terms of probation and what is ever asked of you by Ms. Walsh. Understand if they have reasonable cause to believe you are in violation of your conditions of probation, they have the right to search your house, your car, your phone, your purse. You got it? All right. Report any arrest, please contact loss of employment or change of residence within 24 hours. Are you working?
I provide daycare for my grandchildren, so my
Okay.
daughter can work. She's a CNA at over by Runway Medical.
Okay, I need you to repeat that again.
I said I provide daycare for my daughter, for my grandkids. She's a CNA over at Runway Medical.
Okay, how many hours a week?
She works third shift, so it's 40,
Okay.
sometimes more.
All right, and that's fine as long as you're making payments on your fines and
Yes.
costs, all right?
Yes.
So I will count that as employment. There's a $30 per month supervision fee, 60 if we have to put you on tether. There's a crime victim assessment fee in the amount of $130. I'm gonna order $750 in court costs and then a $60 DNA fee and $68 in state costs. Now, Ms. Walsh is really good about this. She's gonna give you a monthly amount you have to pay. And if you pay it, at the end of your probation, it's all paid off, all right? But understand, your guidelines allow for up to a year in jail if you violate repeatedly. So if you get in trouble with probation, you could go to jail. All right. Now, on the assault and battery on file number 24-21857FH, I'm gonna give you credit for 2 days served. There's gonna be a $75 crime victim rights fee and $53 in state costs that you have to pay. So Ms. Hannawalt, you know, you do have some prior offenses. You don't have medical marijuana card, do you?
No, ma'am, I don't smoke.
All right, and if you're on psychotropic medications, I don't want you smoking marijuana either.
Yes, ma'am, I don't smoke.
Okay. Ms. Walsh, anything to add? And I'm not doing probation on the misdemeanor. I'm just gonna
Okay.
give her credit for time served. Anything else, Ms. Walsh?
No, I need you just to come see me Tuesday at 1 p.m.
At 1 p.m. So you want me to write that down? You got it?
And paper, but one was.
Okay, good.
I did make mistakes this time.
All right, you write that down. And then, Ms. Hannah, my bailiff's gonna hand down to you your notice of right to appellate review. He's gonna have you initial and date one copy for our records, just to acknowledge you received it. If you wish to appeal your sentence, you would fill out the information on the forms and mail them to the address listed on the form within 42 days, or drop it off here.
All right.
All right? All right, so go ahead and initial and date that. All right, so Tuesday at 1 o'clock, you report to Ms. Walsh, and I wish you the best of luck, all right? Thank you. All right, I have received back, signed copy of the notice of right to appellate review on both those files. And, okay, so I have finding file, Ms. Rodriguez, hold on. There we go. All right, Ms. Rodriguez, can you hear me?
Yes, Your Honor.
Excellent. All right, this is in the matter of the people of the state of Michigan versus Maria Rebecca Rodriguez, file number 24-21897FH. This is the date time set for sentencing. I also have a contempt of court sentencing for failure to drug test as ordered. So there is that contempt of court sentencing too. We'll address Mr. Glazier. Let's see, she also, failed to appear for pre-trial on September 18th. So we have several failure to appears and, okay. So Mr. Glazier, you received a copy of her pre-sentence report.
Yes, I did, Your Honor.
All right, Ms. Rodriguez, did you get a chance to read and review the pre-sentence report?
Yes, Your Honor.
Okay, did you get an opportunity to speak with Mr. Glazier and ask him any questions you might have?
Yes, Your Honor.
All right, are you satisfied with Mr. Glazier as your attorney and the advice that he gave you?
Yes, Your Honor.
All right, Mr. Glazier, do you wish to explain or challenge the accuracy or relevancy of any information in this pre-sentence report?
No, Your Honor.
Does the pre-sentence report disclose any prior convictions in which there exists any known constitutional defect? I have 21 prior misdemeanors and 1 prior felony listed.
No, Your Honor.
The probation department computed the minimum sentencing guidelines to be 0 to 11 months. Do you agree with that computation of guidelines?
Yes, I do, Your Honor.
All right. Let's see. Before the court passes sentence, is there anything you'd like to say on behalf of Ms. Rodriguez?
Your Honor, Ms. Rodriguez has a problem with drugs and she knows she has to take care of that. I think the recommendation was for 3 years probation, 6 months in jail, credit 37 days, but she could be released to a program. And she wants to take advantage of that. She wants to get into a program. I would indicate to the court she got sentenced down in Judge Shadler's yesterday to 93 days, but she can be released after 30 days. I think she's probably got almost that type of credit in down in district court, but I'm not sure. But She would like to go to a program, and I don't know, is the circuit court gonna attempt to try to get her into some kind of a program, or is that something we need to try to do, or
I believe Agent Chesky will do that.
she'll try to get her into some kind of a program?
Yes.
Okay, if there's a problem with it, you can always call our office and we can maybe try to help out too, if that's
Okay.
necessary. But that's what she's doing, Judge. She'll do the jail till she can get into a program.
Okay. All right. Miss Adams, if you want to call and tell them I'll take Hopkins early if they want, I can do that unless he's zooming from out of county. Or
Okay.
is it a hearing?
Nope, it's just an extradition arraignment.
Okay. Okay. So Miss Rodriguez, is there anything you want to say on your own behalf?
I'm sorry, I'm trying to get my life back together.
Ms. Rodriguez, thank you. In determining the appropriate sentence in this case, the court has considered the seriousness of the offense, your history, the principle of proportionality, the statutory penalty, the cost of confinement, the sentencing guidelines, the report and recommendation of the probation department, as well as what has been said upon the record at this hearing, the criteria and reasons for the sentence and the nature and gravity of the offense, the discipline appropriate to its commission, deterrence against repetition by you and by others, the potential for reformation, vindication of the law, and the protection of society. It's a sentence of the court that you'll be placed on probation for a period of 3 years. You will serve 180 days in Lenawee County Jail. I will give you credit for 37 days. Ms. Teskey will work with you, and if you wish to attend a residential inpatient treatment facility, that would be great. But understand if you get kicked out or you leave, that will be a violation of your probation and you can end up doing even more jail time. Do you understand that, Ms. Rodriguez?
Yes, Your Honor.
During your term of probation, not to use any alcohol or illegal controlled substances. You must comply with drug testing as required. Must attend meetings, AA, NA, or CA, or whatever type of meetings at the frequency required by the field agent. Complete any treatments if referred, whether it be outpatient or residential. Complete your GED or adult education if you haven't done that. Engage in any psychological evaluations if referred, not to engage in any assaultive, abusive, threatening, or intimidating behavior. Can't use any item as a weapon, can't possess any weapons. The probation officer has a right to enter your property at any time for supervision purposes. And if they believe that you have violated the conditions of your probation, they will have the right to search your person, property, car, phone, purse, whatever it might be. You must report any police contact, loss of employment, or change of residence within 24 hours. There's a crime victim assessment fee in the amount of $130. Supervision fee in the amount of $30, $60 if we have to use a tether. Court costs in the amount of $750 and $68 state costs. Understand that Ms. Teskey will give you an amount to pay monthly on that. And then you need to make those payments, or that could be a violation of your probation. Ms. Rodriguez, you know, I read this and I know that your life has been a struggle. You don't seem to outwardly take this seriously. During the pre-sentence interview, they said you were kind of laughing and not paying attention and not trying to engage. You have a really extensive substance abuse history going back to when you were a kid. So obviously, you know, you state that you were using heroin and crack daily. You said you can stop at any time, but you just don't. You didn't want to join the Lenawee County Recovery Court program. So, you know, you have 5 children and you've lost your parental rights for all of them. You don't acknowledge your mental health or substance abuse issues. And you violated bond conditions and everything else the whole time I've had you here. So, you know, at the end of the day, I go home, Mr. Glazier goes home, everybody here goes home. And we hope the best for you, but we can't make you live a better life. I want you to. I know that you're a good person. I know that you had awful, awful things happen to you. And that some of this behavior is a reaction to that, but you can make these changes and I want you to, and I hope you do. So, I don't think I've missed anything, Ms. Walsh.
Judge,
Yeah.
the contempt.
Oh, I'll give you 90 days in jail with credit for time served on the contempt. Looks like you probably got, I'll give you 37 days time served on that one and 90 days for the contempt. We're gonna send over to you, or Ms. Walsh, did I miss anything?
Judge,
No.
on the contempt, can she be released to the program? If
Yes.
they get her into a program?
Yep. And all of these, you can be released to a program once a bed becomes available, but you better not run on me. Because you know what I can do? I can send you to the RAP program where you're gonna be locked down and required to do substance abuse counseling for a year. So
It won't work.
I want you to do this your way and I want you to do it the right way, okay?
Thank
So we're gonna send over to you your notice of right to appellate review. They're gonna have you initial and date one copy for our records, just to acknowledge you received it. The other copies are for us. If you wish to appeal your sentence, you would fill out the information on the form and mail it to the address listed on the form within 42 days. All right?
Okay, thank
So
you.
good luck to you. All right?
Thank you.
Thank you.
Thank you, Your Honor. That's all I have with you.
All right. Thank you. And thank you, Ms. Rodriguez. You're all set.
Have a good day. Thank you.
You too. Ms. Walsh, thank you. And I just have an extradition hearing and that's it.
Is Tommy on there?
Tom Moore is on here.
You know,
I don't know why.
Yes.
It's just,
what are you doing?
we are live on
Excuse me?
YouTube, so I really don't want to know what you're doing right now. So
You're asking me, I'm across the hall from you.
Why are you on here?
In case the judge needs me, it's my duty day.
Oh, you're so you're so good, Tommy.
you know, it's
Thank
so
you.
nice that he's back because he truly is the only one that's really attentive to me. No, I'm just kidding. So
Yeah.
all right.
Excuse me.
All right.
I knew Ms. Walsh would get upset with that.
Anything
Thank you,
else you need,
guys.
Your Honor?
No, you guys have a good weekend.
You
Thank
too.
you.
All right.
Bye.
Bye.
All right, so if I have somebody in jail room 4, I am looking for Mr. Hopkins. Well, I'm gonna take these files to Ms. Adams while I'm waiting for the jail window.
Oh, it's just that, just between Maple and Springbrook, there's a street. Goes
Yeah.
through. And it's
That's
right
what, yeah, seriously. All right, Mr. Hopkins, can you hear me?
Yes, I can.
All right, good morning. So this is in the matter of the people of the state of Michigan versus Randall Eric Hopkins, file number 24-22075AX. So Mr. Hopkins, we are here on an extradition. So this is a proceeding to determine whether you wish to waive your rights to extradition. Extradition is a proceeding to return you to another state in which a warrant has been issued for your arrest for the commission of a felony. It is in effect a demand by another state for your surrender and to return to that state to face the crime with which you are charged. So I'm looking at this state of Indiana failure to appear warrant. And it's, every state does this different. So okay, Cusco County, do you know how to pronounce that?
Kosciuszko, that's how they say it.
Okay, yep, totally wouldn't get that. And it's for failure to appear warrant, and the charges are August 5 of 23, felony 6 degree, which is operating a vehicle as a habitual traffic violator when defendant, and then misdemeanor of operating a vehicle while intoxicated, and then another 6 degree felony operating while intoxicated prior conviction within 7 years. So 2 of those at the very least are felonies in the state of Indiana. So we cannot in this court in this state determine the truth or the falsity of the charges made against you in the state of Indiana. So we can't determine guilt or innocence or anything of that nature. You do not have to waive your right to extradition. You can require that the governor of the state of Indiana make a demand upon the governor of Michigan for a warrant for extradition. You have the right to demand and procure legal counsel. If you cannot afford an attorney, the court will appoint one for you at county expense. If your attorney wished to test the legality of your arrest, you may apply within a reasonable time for a writ of habeas corpus. That is a writ by which your custodian is required to bring you before the court for the purpose of having a hearing to determine the legality of your arrest. So do you understand all the rights that I've explained to you?
Well, except the last part, where is the hearing that I would be challenging the legality?
Okay, so the hearing to challenge the legality would be held here, okay? And we don't determine the legality of the charges against you. Just, we would make basically determinations on one, are the charges against you in Indiana a felony in the state of Indiana, because we only extradite on those. And then if they are felonies, have you been properly charged? Like, we wouldn't determine guilt or innocence of those Indiana charges. So
You're saying, when you say properly charged, you mean by statutes?
yeah, like, are they a proper statute or a law in the state of Indiana? But what I was going to add, if you can't afford to hire an attorney, I can appoint someone to talk to you to give you legal advice. Would you like an attorney appointed to represent you?
Would I have to not sign extradition papers today to do that?
No, I would have someone talk to you today. I mean, I would get someone here in a couple minutes.
But yeah, I'd like that, please.
Okay. Yeah, it's always good. So, all right, so you're gonna bear with us for a moment and we're gonna make a call to get someone here and give us just a few minutes and we'll be with you in a minute, all right?
Thank you.
All right, thank you. I'll be right back, sir.
Thank you.
Yep, I gotta. Some paperwork. Hold on, we'll be right with you. We haven't forgotten you, okay?
All right.
Michael Decker. All right, so just 1 second. All the attorneys were in other courts, and so we have Mr. Decker Margosian that's going to log in to talk to you. Thanks. All right.
Can I ask you a question?
Okay.
Oh.
No, I've got your attorney now,
Okay.
so you can talk to him. All right,
thank
so we have senior trial or public defender Michael Dagger-Margosian present. Mr. Dagger-Margosian, thank you so much. This is Mr. Hopkins, and I believe Ms. Adams emailed to you the extradition paperwork. So I'm going to open up a breakout room, and then Mr. Dagger-Margosian will talk to you for a moment. I don't know why that guy's. Hold on a second. Okay, so I'm gonna assign you two to a breakout room, maybe. There we go. All right, go ahead and join that breakout room. You'll get him back in 2 seconds. You're looking for Michael Dagger-Margosian?
He's before our judge right now.
But he was waiting because you were doing another hearing.
Yes.
So I stole him for 2 minutes. He'll be right back.
You're responding, not responding.
Yeah, no, I'm surprised she's not.
Her phone's in.
We try calling her. It's just weird. Will that get there in time for this day?
What's that, George?
The package will get delivered in time.
I think, yeah, because we put together till Christmas Eve, yeah,
Okay.
yeah, thank you. Thank you for that, that was helpful, thank you.
See what comes down here looking for me. Hi, Mr. Hopkins. Hold on, Mr. Dagger-Margosian's coming in. Mr. Dagger-Margosian, I did, I know, steal you from another court. Let's see if he's there. Was he there talking to you, Mr. Hopkins?
Just long enough to tell me he had to do something.
Okay, so he had to go back into Judge Olsaver's courtroom, so he'll be back in just a minute, all right?
Okay.
All right, so give us a minute. I'll be right back. Michael, forget it. Never mind. All right, Mr. Hopkins, now I have our regular scheduled attorney here. So I'm gonna let her in and talk to you. Mr. Dagger-Margosian was just helping out, but he had to get back to his other hearing. So, Give us just a minute. Miss Underwood, you with us?
I am.
Awesome. I'm so sorry. I think I just traumatized Mr. Dagger Margosian because I have another hearing and I asked him to pop in for you. But he didn't have much time to talk to Mr. Hopkins. So Mr. Hopkins is here on an extradition. Do you have the paperwork then?
I do.
All right. And so Mr. Hopkins, I'm gonna put you back in a waiting room, this time with Miss Underwood, where's my breakout rooms? There we go. Who will talk to you. And let me hold on. Let me delete this room.
Thank you.
And here we go. Now I'm going to do it again. So Miss Underwood and Mr. Hopkins, go right ahead and join that breakout room. Miss Adams, I'm gonna step back and ask you a question. Thank you. Okay, I'll be right back. You must have a lot of questions. It's fine. It's fine.
Your Honor, I'm sorry. I came out too early.
She'll be right back, Rhonda.
Hear it all. Big speaker. I watch the courtroom when I'm editing.
You don't want to hit the door.
All right, let me.
Your Honor, I'm
Oh, is that-
sorry. I came out too early.
You want back in? Go back in.
Oh, I guess I can by myself, can I?
Yeah,
Okay. Thank you.
okay.
Oh, gosh. I'm so bad. I don't have breakfast and then by this time I'm starving. Oh. Hi, Michael.
Rhonda's doing it.
It looks like I got kicked out of the thing, so.
That's okay. Yeah, Rhonda.
Rhonda
Rhonda's
finally
there.
showed
All
up.
right, sorry about that.
No, Rhonda popped in.
Sorry,
So I'm
Judge.
sorry I stole
No,
that.
I thought it's one of those mornings, I've been,
No, I knew you had to do judicial savers,
I was
but
gonna do the thing and then, so,
it's okay.
all right,
But Rhonda did pop back in, so
so we're good then?
we're good. Thank you.
All right, thanks.
And now you know how to do them if you ever have to again.
Well, she's
You know,
gonna do it right
I
now,
do,
Quincy.
but it's just like, I'm gonna keep my little, can I keep the cheat sheet?
Yeah, if you want to watch it, we'll do it right now. All right. All right, Miss Underwood, poor Mr. Daggermark goes in. I kidnapped him from Judge Saver. So I'm gonna bring back, I've closed the Zoom room. So Mr. Hopkins, welcome back. So have you had a chance now to speak with Miss Underwood?
Briefly, yes.
Okay, do you need more time to speak with Miss Underwood?
I don't believe so.
Okay, are you satisfied with the advice that Miss Underwood has given you?
I'll sign.
Okay, that was my question. So, I mean, Mr. Hopkins, I will tell you, I also represented people on extradition hearings. And so did Miss Underwood explain to you what the process is?
Yes, she did.
Now, you may not be happy about maybe potentially going back to Indiana. We all get that. But you want, do you understand enough now to make an informed decision on whether or not you should sign the waiver of extradition?
Yes.
Okay, and do you have any more questions?
No.
Okay, and, all right. So, do you have the paperwork with you?
I have 4 forms in front of me, all identical.
Okay, excellent. So do you want to waive your right to extradition to a writ of habeas corpus and to, and go voluntarily to the state of Indiana to face the charges made against you in that state?
Yes, I do.
All right, so if you can please sign each of the forms. Today is December 13 of 2024. Let me know when you are done. Hopefully they'll pick you up and you'll be out before Christmas. Have a good holiday if I don't see you. I probably will next week though.
I kind of scribble on the back of one of these. Is it gonna be, do I get to keep one or?
Just say it again.
I kind of scratched on the back of one of these, some notes. Is one of these gonna be mine
No, so why don't you go ahead and just scratch that out?
on the back?
Yeah. You may get one copy, I don't know.
Exactly.
But I know one goes to Indiana, one goes to Sheriff Department, one goes to Lean, so I'm not sure. I'm sure you two probably get one copy, all right?
Actually, there's 5 here.
Okay,
You
so
only
yeah,
need
just
4?
tell me you want to keep a copy. Yeah.
Okay.
Did you sign all of them?
I think that's the only one I didn't sign that I scratched on.
All right, go ahead and sign that one.
All right, then.
All right, so will you raise your right hand for me? Do you swear that the signing of these papers is your free act and deed for the purpose of waiving extradition?
I do.
All right, so sir, hopefully they will come pick you up and you'll get there and processed and out before Christmas, but I wish you the best of luck, okay?
Thank you.
All right, thank you. Miss Underwood, thank you as always. Beck.
Your Honor, this was scheduled for 10:30, correct?
Yeah, it was.
I didn't think I was late.
You weren't late, but we were trying to do it early, so we were trying to track you down
okay.
and steal you from wherever you were,
All
so.
right.
All
Thank
right,
you.
thank you.
Have a
Thank you
good
all.
weekend.
Have a good holiday weekend. Bye. You're all set, sir. You just go ahead and let them know you want to keep that one copy.
Oh, all right.